Legality, Hangouts and Headlines edition. Thank you all for joining me on such short notice. I was trying to fit this in to my day. If you were with me earlier this morning, you know I've already been streaming for, I think it was a 6-hour stream today, and I had a great deal of fun with it. I know law tubers all across YouTube are doing their own streams here on an off day for the court in Depp v. Heard. Or is it? Is it an off day in court for Depp v. Heard? Well, if you've been following along with us or Alita at Legal Bites or Emily D. Baker or any of the other awesome lawyers that are talking about this across YouTube, you know that it was an off day for us. It's not a public court day in the trial, but it is a day in which there is work being done. What work is being done? Well, we know from what the judge told the two parties in public that they were going to be working on hashing out jury instructions today. People have asked me about what those are, and the easiest way to think about it is that the jury are lay people. The jury are not lawyers, and they're basically sat down and said, here, you're going to work on this for 6-7 weeks, and you're going to pay attention to what is said. We're going to have opening statements to kind of give you a roadmap to some extent of what we're going to be talking about, but not a ton of additional information other than don't check your social media. At the end of the court process, at the end of closing statements, the jury will then be read/given what are called jury instructions. I'm going to bring up some examples of that for you as we talk about this. I intend this to be a very short surgical strike Camille Vasquez type video, but I wanted to get this information out there because I've got about 600 tweets on this asking me to further explain myself and what I have said about a court TV leak report that happened today. We're going to get to all that. But at the end of the trial, the jury is given these instructions. Jury, here's what defamation means. If you find element X, element Y, generally speaking, a false statement that injured another, all these various things that can be described in different ways, then you're going to find for the plaintiff. If you do not find all of these things, you're going to find for the defendant. We try to make it easy and intelligible for a lay person to understand. But they differ in every court case. Why? Because it's very, very important what the jury is told, how they're supposed to make these decisions. So both plaintiff and defendant argue about these things. What we heard in court in the last week or so was that each side had submitted to the judge their version of their preferred jury instructions. This is how we would like the judge, the court, to inform the jury about what their legal obligations are. And because wording and how they are described can change how a jury might otherwise answer the ultimate legal question, they are quite contentious. So the judge told those parties when they were discussing jury instructions, said, hey, you guys told me what your versions are. You haven't told me what you agree upon and what we need to fight about. So she ordered the two parties to get her that information by Thursday night, last night, and say, then we can know what we get to fight about on Friday. Friday has arrived. That's today. It's a closed session of court. And she says, you guys only have a couple of hours. You need to be clear on what we're going to fight about. And they proposed alternative jury instructions for various questions that would be presented to the jury. Here's how defamation works. Here's how defamation might work in the countersuit. Here's how vicarious liability might work, which doesn't have to be called that. You're going to hear a reference to the principal agent liability or things along those lines. Same kind of concept. When can one person, Johnny Depp, be held liable, can be forced to pay damages and otherwise injured by the court system for the acts of another? Adam Waldman. Right? All the facts are out there and understood. Adam Waldman said some stuff, and Johnny Depp is not the person that said those things. So should Johnny Depp be held liable for that? And one of the things that you would have to inform the jury on is what is vicarious liability? When might it be the case that Adam Waldman can be considered for legal purposes to be acting as Johnny Depp's agent so that you might otherwise assess a damages claim against Johnny Depp, who didn't do any speaking in front of you? That's the kind of instruction that gets fought over. And you want to remember that as we go in and discuss what was leaked out from court TV today. So let's take a look. Or not. We'll share it whenever the thing feels like it. How you guys doing? All right, good. It's up on our screen. So this is a Twitter thread from Chanley Shaw Painter. And if I got that wrong in pronunciation, I very much apologize. She is a reporter from Court TV. I believe, and I'm not positive, that she is the person that is called out for her brightly colored dresses in court. You can generally see her sitting on the Amber Heard side of the courtroom, pretty close to the front, and looking and taking notes and otherwise paying attention to the proceedings. It has been clear for some time that she is also getting information from one or both sides to talk to you about. If you go and follow the tweets here, we were told what she thought, she reported on, were going to be the witnesses that Amber Heard's team brought in their defense. And it was mostly right, although you may have heard me on these streams or on Twitter calling out what I thought was clearly wrong information, such as that Johnny Depp would be called back on the defense side. Now, hey, that might happen next week still, but I had my doubts. I still have my doubts. I wouldn't call up a very slow-talking opponent party when you only have 8 hours left in your case. But that's just me. Today, she went out with a series of tweets, some of which are very interesting, one of which has driven the internet mad. And we're going to be focusing on that last one, but let's talk about all of them first. So this is the reporter from Court TV, says, new info, hashtag Depp v. Heard. Now, there is an opening question when you get this, which is, this is a closed session of the court. This is just supposed to be the parties. Is there a Court TV reporter sitting in there? Were they given special access of some kind, which I doubt, but isn't impossible? Or is she receiving information from another source? As I said, what we have gotten from this reporter and Court TV in general are pieces of information that very much sound like they're coming from Amber Heard's team. That is not to impugn anything. That is just to say the best information we have received from this source are things like what Amber Heard's defense is planned to be, what witnesses are coming up, and when. Now, you do hear some alternative things. You hear that, for instance, Jennifer Howell is anticipated to testify for the Johnny Depp side. It's a pretty good educated guess considering they laid all the foundation for it, but maybe they're getting leaks from the Depp side of things as well. We don't want to just speculate on such questions, but it seems clear that at bare minimum, she has an open pipeline with the Heard team. That is also interesting because one thing we heard pretty aggressively, at least as far as this judge goes yesterday, was that the sides were prohibited from making announcements. She had gotten sick of the Amber Heard PR team, which, to be fair, was started off by Johnny Depp's team talking about Amber Heard's performance on her direct examination, talking to the public about things happening in her courtroom. So one of the things she says at the end of trial yesterday is, I don't want to hear anything from Johnny Depp or Amber Heard or their representatives out in the media, which is good, I think. I think that helps keep the sanctity of the trial situation. It is obviously developed into a certain kind of circus, and the judge doesn't want to help advance that ball any further. But could you leak information if you wanted to get it out there to a Court TV reporter if it otherwise benefited you? And could that Court TV reporter take it on faith that what you are telling her is exactly true or characterized correctly? We'll see. Let's look at this a little bit further. Today, attorneys met with judge hammering out instructions, those jury instructions. We're going to talk about those, believe me. Each side has 2 hours for closing arguments. And this is a little bit different configuration than we assumed would happen. Johnny Depp's closing, Amber Heard's rebuttal/closing, Depp's rebuttal, and Heard's argument only on counterclaim. So actually, in this format, as described here by the Court TV reporter, Heard's argument, Heard's team will be heard last, which is very, very interesting. Right? We had assumed that Johnny Depp would be the last voice you hear. He's the main plaintiff. But here, Amber Heard is the last voice you hear, but it is supposedly limited, and this will probably get some objections, which are rare for closing statements, but could still happen. This might get some objections where they go outside the scope of what is at least described here. Said another way, Johnny Depp gets to present his case in chief. Amber gets to present both her case as defensive of Johnny Depp's claims and her counterclaim closing. Depp gets his rebuttal to the main case and her counterclaim, and then Amber Heard gets to go rebutting whatever Johnny Depp just said with respect to only the counterclaim. We'll see. We'll see exactly how that looks in practice or whether or not I got that summary right, because tweets aren't the best conveyors of information, and we'll see how it goes from there. But let's continue, because this is interesting information, bare minimum, if wherever it's coming from. Painter continues, closings are scheduled for next Friday. We knew that. Arguing for Depp will be Ben Chu and Camille Vasquez. We realistically knew that. And arguing for Heard is Elaine and Rottenborn. So same configuration as the opening statements. They get 2 hours total for each of this. So this is 4 hours of talking, 2 hours for each team on Friday of next week. Get excited for that one. That's actually going to be very, very interesting. That's where the lawyers get to use their rhetorical flourishes and drop bombs without having to actually work with the witness. And I anticipate it will be something to watch. Now, continuing on from there, we get a little bit more information. The jury, 2 alternates will be designated after closings, but the judge will have them on standby in case she loses a juror. So they are alternates They're kicked off the jury, but they have to still remain essentially cloistered from all information to potentially still be a viable jury member if, as we talked about in my earlier stream today, the appendix burst doesn't happen before closings, but instead happens afterwards. If some juror just has something happen to them, God forbid, something serious, then an alternate is ready to go. Current makeup appears to be 6 men, 3 women, with the various descriptions that we have seen. We've, of course, gotten that information from Rob and Ian and DUI guy and James, so we know that to be true. And then here comes the big tweet. Today, when jury instructions were finalized, that's your preparatory statement. This is about finalizing jury instructions. Now, let's talk about the court system for just a minute. When we talk about the court system, you have a judge and you have a jury. The judge is in charge of determining items of law, things that actually don't matter about the facts so much, right? Like you have to establish that there's a certificate for possession of a weapon. And if that isn't in existence, that's really not an open question. That can just be legally. That's what happens under the statute if you don't have that certificate. Things that don't require actual fact determinations. Everything else is to be determined by the jury. They get to decide, okay, is that an employment relationship? Is that relationship sufficient to, I don't know, serve as an agency relationship between Adam Waldman and Johnny Depp for purposes of evaluating statements that he might otherwise make and get reported in the Daily Mail or other outlets? Here is what Painter reported, and I think bare minimum, it's just unclear enough for the internet, right? The judge ruled that Adam Waldman's 3 statements, the sources of Heard's counterclaim for defamation against Depp, will be considered as Depp's statements under the theory principal/agent, a win for Heard. And then you'll see some tweets that I made that say, hey, that's the wrong way to spell principal in law, because I was feeling pretty snarky about this, because this doesn't make a ton of sense to me, right? When we talk about finalizing jury instructions, what you are doing is finalizing the instructions that you are going to give to the finders of fact as to what to do when they find certain facts. Right? We get a verdict from the jury, an actual legal conclusion. So what the jury instructions do is they apply law to the facts that the jury is going to find. That's why you're arguing that in front of a judge. And the judge can say, okay, so the instruction is if you find this and you find this and you find this, then you can find an agent-principal relationship. As for the judge actually making a legal determination that an agency relationship exists, I find that very, very difficult to believe. And it is certainly in opposite to the notion of having a hearing on how to instruct the finder of fact. You don't reach legal conclusions when you are determining the jury instructions and how you're going to instruct the finder of fact to figure out what the facts they found meant. So that doesn't make a ton of sense here. The judge having a ruling that an agency relationship does definitively exist doesn't make sense. We will talk about that in just a second, because there's actually model jury instructions on this question and what I think is more likely happening here. But also keep in mind that this a win for Heard is its own editorial commentary. So if we do assume that the leaks are coming from the Heard team, this might be how it's described. The judge ruled that there is, in fact, going to be allowed a jury instruction that talks about how you might find Johnny Depp responsible for Adam Waldman's testimony. That makes perfect sense to me. Hey, here is the instruction. We're going to look at some in just a minute. And that's what we decided. If you report that, if you leak that out as the judge held that this vicarious liability instruction can go in the jury instructions, it is entirely defeating the purpose of how the actual adjudicative system is supposed to work. And it results in 700 tweets coming into me asking me what the heck is going on. Because one of the things that I had said is when the Amber Heard team winds up resting, they are going to face a motion to dismiss, a motion to strike as used in the Commonwealth of Virginia that says the Johnny Depp team will stand up, just like we saw in reverse, and say, Your Honor, we can take all the evidence into account that they have presented. They do not have enough evidence under law. We don't even need to go to the fact finder to actually make a claim that the law can give redress to. And what is the primary way in which they are likely to do that in this particular case? They're likely to say, Your Honor, they've got Adam Waldman's statements. Here sits Johnny Depp. Adam Waldman is nowhere to be found. They have not established that our client, Johnny Depp, is responsible for the actions of this other individual. And they're going to point to that testimony. They're going to say, look, we asked him, are you an employee? He said, no. We asked him, were you directed on these kinds of things? And for the most part, he refused to answer for attorney-client privilege. But that's as good as a no for purposes of actually presenting evidence to the court that the jury can find things on. which means, yes, the court could decide, okay, this is what a vicarious liability instruction would look like, but that assumes, because we haven't faced it yet, that the counterclaim survives to be decided by the jury. All these jury instructions are on separate pages or whatnot. They're all compiled and synthesized into one set of jury instructions that get read. It'll be very long. It'll be very boring. You'll love it. Come see us on Legal Bites when it happens. But at the end of the day, if the motion to strike that the Depp team brings is actually granted by the judge, then all the instructions on whatever would relate to Amber Heard's claim will come out of that package. So what we've got here is effectively a logistical scenario where the jury instructions are approved as if there won't be any motion to strike granted. And I do think you can read it as a signal, maybe, that the court is unlikely to grant that. 9 times out of 10, if not more, the court is not going to grant a motion to strike / motion to dismiss. At this stage, they would rather go get the blessing of the jury to determine these things. But if there's absolutely not one scintilla of evidence, which is a phrase you might remember the judge using when facing the motion to strike coming from the Heard side of the fence, if there's not one scintilla of evidence that you can use to establish that Johnny Depp and Adam Waldman had a principal-agent relationship where at least Adam Waldman was impliedly acting on Johnny Depp's direction, then you can't actually hand that over to the jury, because no matter what the jury finds, they can't actually legally establish that liability. And we will get into that a little bit more. I don't want to just leave you on that legal claim without a little bit more backing, but I wanted to talk about this because I think the best way to read this is effectively the judge ruled that Waldman's statements will be considered as Depp statements if you find these conditions in the jury instructions to be true, right? So it's not a win for Heard other than the fact that, yes, if her counterclaim survives, there will be a vicarious liability instruction. That makes total sense. There would have to be. And it's not that kind of win. And it doesn't suggest to me that somehow in the background, the Amber Heard team rested their case outside the public eye, questioning the entire public trial concept for these purposes. And then after they rested, the motion to strike that Depp's team had prepared was automatically, and in one session where the judge had only said there were 2 hours of time today, gone and ruled against that motion to strike. I still think it's 50-50 proposition. The judge is going to be inclined to send it to the jury, but there is very, very weak evidence to support that Adam Waldman was acting at Johnny Depp's direction. You can believe that he was. I think there's a reasoned position that he might have been, but in terms of evidence, it's not really there. The final tweet here. Finally, there was a question in court today from Camille Vasquez about whether the parties have to be present for the verdict. The judge said their presence is not required, which is interesting because that might actually lower the time between verdict and actually releasing that verdict. That could be interesting on the day. But that's really what we wanted to focus on, and that's what I wound up talking about in my own tweets. I said, first, I'm being snarky here because I really don't believe this. I'm not quite sure how we should take the reporting of someone who doesn't know how to spell principal. I guess we shall see next week. At which point I had a number of international followers say, no, she spelled it the right way. I will guarantee you that this is not the right way to spell principal in the context of a principal-agent relationship in the law. A principal is a person or an entity. It is someone that is responsible for things. A principle with L-E is a philosophical precept, a principle. I stand for reasonable minds can differ. That's a principle. Me, Hoeg Law, the person, Richard, I'm a principal, A-L. I'm a person. So that's the difference there. But I was a little bit snarky. And then I wanted to talk about some model jury instructions, the baseline rule in Virginia. So if we go look at some of these model jury instructions, right? Maybe this one as a for instance that I tweeted out. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer as to the way he brings about that result, right? And you saw or heard some testimony on this from Adam Waldman that said, hey, you figure out how to do things yourself. Johnny Depp is not your employer. You're not getting a W-2, all these various things. And this is important because the main baseline rule, and there are exceptions to all these, and this would be fought over with the judge, etc., is in Virginia, a person who hires, hey, Kurt, a person who hires an independent contractor isn't liable for the independent contractor's actions. So one of the things that you would be deciding in a case like this is this person an independent contractor? Because if they aren't, then you wind up in the employee bucket. Or as I tweeted out, if you instead frame the attorney relationship as an employment-based one, which doesn't really follow with how lawyers work, but bear with me, you could run into a problem. And the Virginia standard here appears to be something along the lines of an employer can be liable for an employee's act if, one, the act was expressly, probably not, or impliedly directed by the employer, or is naturally incident to the business. So is Adam Waldman, as Johnny Depp's lawyer, naturally in the business of saying things about potential cases he could be in? Maybe. And two, it was performed with the intent to further the employer's interest. Now, if you read those and say, Rick, that's very interesting. It sounds like maybe Adam Waldman could be the agent of Principal Johnny Depp. I say, you might be right. But you might also say, Rick, I'm really enjoying this LawTube stuff, and I've kind of understood the difference between finder of law and finder of fact. Those sound like facts to me. At which point I would say, congratulations, you're doing great. If we actually look at the model rules for the jury in Virginia, we find ones that talk about scope of employment. We find ones that talk about what it means and where the burden of proof lies on what your scope of employment is, including, this would be an instruction to the jury, in reaching your decision as to whether Adam Waldman was acting within the scope of his employment, you must determine whether he was acting within the ordinary course of such business. In making that determination, you may consider any of the following. One, whether the act was expressly or impliedly directed by the employer. See, you see how these follow the court precedent in Virginia. That's what jury instructions do. Two, whether the act was in the ordinary course of business or naturally incident to the employer's business. Three, whether the act was performed, although mistakenly or ill-advisedly, with the intent to further the employer's interest. And four, whether the act was performed from some impulse or emotion that was the natural consequence of an attempt to do the employer's business. Now, these aren't actually jury instructions that I'm used to seeing in California and Michigan. Ordinarily, you'd have a little bit more of a check the box and where this leads you. These are kind of a little bit more proto-jury instructions. There would have to be things that are built up by the parties and considered by the court in order to arrive at, okay, if I consider all those things, court, where does that leave me? But you can see that this is a jury instruction. This is a concept that says the jury is going to look at this question. So when you get these kinds of things that say the judge determined this, I say, no, that doesn't make any sense with what we're looking at. So as I say in my tweet, I said, so there are multiple questions of law there, but also of fact. That said, if the jury does get the countersuit, it's entirely proper to frame out liability conditions, finding instructions, which is what appears to have been done today. We knew this was a jury instruction fight. We knew they were reviewing the jury instructions. And when we look at this particular issue, that all makes sense. If that countersuit survives, then they're going to get some kind of vicarious liability, principal agent jury instruction that says, is this person employed? Is that employment such that Adam Waldman is acting in the scope of his employment? You see some things that are bad for Johnny Depp on this in terms of Virginia rules, which says, hey, if it's ultimately within the scope of employment, if this is the kind of things that lawyers do, even though he might be mistaken, even if he goes too far, Virginia would suggest that you can still be held liable as that person's employer because they were otherwise trying to advance your interests. And the law says, where should that risk live? I'm sorry.
I wonder if there's a distinction here between whether a person is an employee and whether a person's acting within the scope of their employment in terms of those being different issues. Because let's suppose you have a true employer-employee relationship, like, just your typical work.
Yeah,
Domino's delivery drivers. The first thing that came to mind, so why not?
Yeah.
Domino's delivery drivers working for Domino's, and they're doing their Domino's related things. Okay, so they're employee, fantastic. So next question we might have to ask is whether or not that Domino's delivery driver, when they do X, are they acting within the scope of that employment, which is a different question, right? So like in this hypothetical universe that I'm now constructing, they're driving the Domino's car, they're wearing the and or driving the employee uniform and or whatever, right? So like these are possibilities, but it's still possible they're not acting within the course of the employment because of other considerations.
Right. If we think about this, pizza driver's perfect, right? Because they get into a car accident while delivering a pizza.
Sure.
You're likely to have vicarious liability. They go to a motel to do some crack or whatever else they're going to do, and they somehow do something that damages the property over there. Probably not scope of employment, even though they're wearing the Domino's shirt and doing these various things.
Yeah, even though they took the Domino's car and wore the delivery shirt and probably brought a Domino's pizza to the crack party, all those things. Yes, I tend to agree. But I wonder if there's a sort of a one notch up question that might be a straight legal question about whether or not this is an employee-employee relationship before you even get into the question of whether it's within the scope of that employment. So the reason I asked the question is because I wonder if like the next level up question about is this Waldman Johnny Depp relationship, is it even an employee relationship or is it an independent contractor, and whether or not that question is a separate question that might be a question of law. So
yes, and that could be the kind of thing that we're looking at here. which says they fought about, hey, he's an independent contractor. This should all be, none of this should be in. But at the jury instruction level, I still think chances are this judge, from what we know about her, is still prepping jury instructions as if the jury's getting all the questions.
Sure.
And so you'd assume that, one, there could be a jury instruction that says, hey, here's the difference and here's how to pick it. I tend to agree with you, Kurt. Independent contractor versus employee might well be a judge question of law type question that could be answered at that level.
Yeah.
But
I've seen things like that because there's tests along these lines, and there's different. The federal government uses one, California uses one.
Yep.
And I've the last time I remember reading one, it was like a 13-factor test on whether or not
I think we're up to 19. I think the Department of Labor uses 19 factors.
Yeah.
Now.
Yeah. So it's like a 13-factor test, 19-factor test. But I wonder if that question is still a question of law.
Yeah, it would be interesting, because if you think about AB5 in California or something, and you wind up with a test that says you are not an independent contractor if you are performing what is like the primary function of the business. Like, that to me is still like an evaluation for the jury. What is the function? Are you performing it to get to that kind of level? I don't know that for sure, though. And certain courts and certain jurisdictions are going to have essentially almost house rules as to what is a finding of law on things like that, where it's just not felt like the jury has the proper expertise to determine those kinds of minutia type things. Either way,
I think on just a sort of practical level, asking a jury to try to determine 19-factor test, you might as well just ask them to look at chicken entrails, because there's no goddamn way.
I hear you. I do hear you on that. I do hear you that. So what I do know, and I think Kurt's points are very well taken, is that I do know that the judge is extraordinarily unlikely to have determined that Adam Waldman's statements are Johnny Depp statements as a matter of law. So I do think you could get to, as Kurt suggests, he was an employee, that we're going to consider him an attorney employee. I still think you wind up talking with the jury about what did he say? Was it within the scope of the employment? And where I find myself really having a problem with that and thinking that it probably should be kicked out on a motion to strike is we have no context for what the engagement was, what the expectations were, what the communications were. And that's because of attorney-client privilege. So if you don't have that scintilla of evidence, if I'm the judge, I'm inclined to listen pretty strongly to that motion to strike. But what I can tell people is that regardless of what this says, I don't believe there was a arresting case from Amber Heard today. That doesn't make sense in the context of this hearing. I don't believe there was a motion.
But I heard they discussed motion to dismiss. Did they not?
No, this is all we have on this.
Okay, because I guess I misunderstood what people were commenting.
I think this is what people are basing it on.
I was under the impression that they discussed the issue of dismissing the.
Okay. Yeah, this is what they're basing it on. This tweet is what they're basing it on. Where the reporter says, judge has ruled that 3 statements will be considered as Depp statements under the theory principle of agent. And I just
the judge definitely didn't say exactly that. I'm sure could be as good as the judge is going to get.
Yeah. And if you're thinking about how jury instruction works, it's here are the conditions that would lead to that. We're talking about, today when jury instructions were finalized, I can't say this is the context. And then out of the blue, the judge says, no, he's his agent. You sure? No,
I could definitely see that. I could definitely see, like, because the idea of the lawyer-client relationship, like in terms of like your standard case, which is, you go to, unless you have a guy who's just on permit retainer or something, like I think your typical lawyer-client would have to be just a matter of law. It's hard to believe that question has just not been determined legally somewhere.
Well, most jurisdictions say that an attorney is an independent contractor.
I would think.
Which is going to lead to non-liability, and then there are exceptions to that. So I don't know. It's interesting. I would be very surprised if the court made a definitive determination during jury instruction finalization that this is no longer a pending.
I'm his employee, so I'm the attorney. I'm his employee, but he's paying. Okay. And he's paying me as the employer. No. This is
the argument here, as presented here, and what Heard's team is going to present is that Adam Waldman is Johnny Depp's agent, which usually requires an employee-employer relationship, and that And that's why you have those questions from the testimony. Do you file a W-2? Can Johnny Depp fire you? Does he control what your strategies are? All things that really didn't get answers.
Which I know the answer to that question, no.
Yeah, no. And this is why I say, when I'm tweeting out, I say, you can run into trouble if you're in an employment relationship, but I've said in the parenthetical, that doesn't really follow with how lawyers work,
No.
right?
It's
if
like,
you're hiring an outside lawyer.
Can you control lawyer strategy? No.
No. The lawyer can fire you. I mean, the lawyer could say, okay, this is you're
well, the rules of ethics tell me I can ignore him.
Yeah. Well, and you have to still do zealous advocacy regardless
of what your client is saying. But that doesn't go to his ability to control my strategy to achieve those ends.
No, sometimes it can be an opposite to it. You can say, this is the right strategy.
Very much so.
So no. I just fundamentally don't believe this is what people have said. Oh, there must have been a motion to dismiss and she must have held against it, because this looks like a holding that you would find when she denies the motion to dismiss. Right. And I do not believe that happened outside the public eye. I do not believe that happened in the 2 hours she allotted for jury instruction fights. So what I think this is describing is something like
2 hours for it. That's hilarious.
Yeah. Well, she said she had stuff to do. It was like 10 to 12, I think, today. So they might have gone over that because, everything is like at least an aspirational deadline.
Man,
Yeah. Not with this judge. She was gone. She was a ghost in the wind. But here, like, will be, I think, is too strong.
Will be is way too strong.
So my best guess is that she allowed instructions that would allow for Adam Waldman's statements to be Johnny Depp statements. This was read, probably leaked by Heard's team as a big win to the court TV reporter. She went out with this and everybody freaked out. I say that to Ian as well. Ian says, so assuming the reports are correct that Waldman's statements are attributed to Depp, then the counterclaim will not be struck, which means the odds of no winner drop quite a bit. It's likely that money will change hands one way or the other. And then I respond to Ian and say it would surprise the heck out of me if she did anything other than simply approve the vicarious liability instructions. There are fact questions in an agency determination. I mentioned it in the thread, but I think she approved the instruction, assuming the countersuit is live, which is the right thing to do. It is live right now, which would be an instruction, not some kind of court order. And then you'd still have a motion to strike on legal agency grounds for no employment, no directive, not a spokesperson, outside the scope, all those kinds of things. And then I think if I have it here somewhere, I think Emily dropped in and said, didn't the court say no statements? Is this statement a workaround for Judge A's ruling? I think to some extent it is. I think by all reckoning, Heard's team is leaking to this reporter against what the judge had said. And then she says, I imagine that it's in the context of deciding jury instructions. They haven't had their motion to dismiss yet. I see this as a status quo update. It's clear they are speaking with the Heard camp, but I appreciate the updates on witnesses and timing. So I agree with Emily here that this strikes me as jury instructions got finalized, some of which would allow for a vicarious liability holding, would allow for Waldman's statements to be Johnny Depp's. And because of, let's give the benefit of the doubt, a little bit shoddy Twitter character limit reporting here, it drove the internet bonkers and had my friend Kurt coming into the channel saying, wasn't there a motion to dismiss? So that's what I see having happened here. I wanted to get in here and out like a surgical strike, which in Hoagland is at least a half hour, apparently. But I wanted to deliver that information because I think it is important. As far as we can tell, there's no rested Heard case. There is no motion to strike. We would still expect that to happen after Heard's case concludes. If you want to read this as something useful for Heard, you could say even letting in the instruction could signal that the court is very likely to send this to the jury. Personally, I think every judge is very likely to send the case by the time it gets to the end of week 5 to the jury. But we shall see. I also think simultaneously that Heard's team has not made its case establishing the necessary scope of employment directive, impliedly or otherwise, requirements here.
So I now have to ask the question because I want to double check to make sure we actually know what we're talking about. When we say the judge finalized instructions, do we mean that they just had arguments and that's it? Or do we actually mean the judge actually determined the actual arguments and there's actually some sort of final list that actually exists somewhere?
I think we're supposed to believe from the tweet, and I think it's just not careful that the judge made all these final determinations.
I'm now pressing X to doubt that there are in fact final jury instructions that exist. That's how deep I'm willing to go on this one.
Okay, you don't even think the jury process is done. Well, she didn't have a lot of time.
I believe the arguments are over. I believe that she has all the information that she needs, but that she actually said, "Here are the jury instructions. These are what they are."
Yes, she just picked, right? She just picked that one, that one, that one, that one, that one, that one. We're done. Yeah, it was a very short period of time for a jury instruction fight. There's no question about that. I've got a tweet here from Rob that says she had other felony things to go on today, but we'll get to that in just a second. We will do some super chats now. I'm not going to do a ton. I was on for 6 hours earlier today. I did want to get this information out, but I so appreciate the support. Let's talk about him a little bit. Pretty Nikki, beginning to think you're a robot, Hoeg. Thanks for all that you do. Hearts emoji. I might be a robot. I enjoy this stuff. I saw this. I saw mass confusion, and I wanted to make a video. SM, the Waldman depot didn't prove liability. Can JD be called as the last witness to do so? You told Mr. Waldman to leak, correct? Privilege still exists. I mean,
I would say objection privileged.
Yeah, it's his privilege. Waldman's using it.
You told Waldman, that's privileged.
It's Johnny Depp's privilege. Absolutely. Gio Rio, as the juror of Blue Heart, will you also go compare some testimonies at the end before jury decision? Ask Runkle what he said about court TV and virtual legality. Yeah, I think Kurt doesn't agree here. I think some panelists don't agree either. I think there will be time to do some catch up and reading about other evidence and things that maybe didn't get introduced into the trial during the deliberation phase and on those streams. It might be short. It might be long. We don't know. We do know that Camille Vasquez asked the judge if they had to appear in court to hear the verdict. She said no. So basically, any time frame could happen for the verdict. We wouldn't even necessarily get a big long warning because they're in the other room. Hey, Nate, how you doing?
Hey, guys. I was jumping in to see if you guys heard the news.
Oh, what news is that?
Amber Heard is recalling Johnny Depp next week.
Oh, whose news is that?
The New York Post. Sources from Amber
Why
Heard.
would you do that?
That's so look now, you know what? I love with her because I was like, you know what? I'm gonna wait to say the New York Post because I know Hoeg will accept it if it's the New York Post because they are so pro Amber. So yes, the New York Post reporting sources close to the Heard team. They're calling Johnny Depp next week.
I can't tell you what the stupidest thing would be for them to do, but this is pretty high on the list. You're going to ask on the slowest speaking witness with 8 hours left in your day, who is with charisma, who is going to have by far the most hostile approach to your questions and still probably remain sympathetic to the jury, all while doing it, and leave yourself with how much time?
And then, of course, the most critical detail, which cannot be ignored, then Johnny Depp's team gets to ask leading questions of their own witness.
How great are you, Mr. Depp?
How great are you, Mr. Depp? Are you all the great? Isn't it true, Mr. Depp, that you're just wonderful and great? Isn't it true that Amber Heard beat you all the time?
Johnny Depp, you might be aware.
Is it true? They probably use all 10 hours on that.
Yeah, I was going to say, you might be aware. We have 10 extra hours to chat with you.
So 10 hours of leading questions by Johnny Depp.
Why don't you sit back and walk us through the creation?
This is now my legal strategy. Just 10 hours of blatantly leading questions.
Yeah, and you don't got to walk him through it. He doesn't have to say anything. You just walk him through it. Listen, just say yes to everything I'm going to say.
Yeah.
That's it.
All you have to do is say yes. Just that's the only word.
Don't worry. Trust me.
Process is some of the finest movies of all time. Would you, Johnny Depp? How did Captain Jack Sparrow get created? Darcy, thank you. I very much appreciate your super chat. You don't need to thank me. I'm thanking you. Tawny M, would it not be a W-2 versus a 1099? So what was trying to be elicited in that testimony, non-testimony deposition video is you don't get a W-2, which would make you an employee, do you? And he didn't answer anything basically of any kind. But no, if Adam Waldman is a legit independent contractor, the baseline rule is that a principal doesn't have responsibility for the actions of an independent contractor. But there are exceptions to that. Lawyer, principal.
The law is nothing but exceptions, right?
The law is nothing but exceptions. It's a good point, Kurt. JJ Flo, didn't Chu ask admin QS in depot if Adam gets a W-4? I think he asked about a W-2. Tax forms are not the be-all and end-all of whether or not you're an employee or independent contractor. And the law can step in and say, you're doing it wrong, employer. And at which point, you'll take on all that liability as if you were and acknowledge yourself an employer, because tax forms don't make that determination for the law. It's still a useful question to ask, of course. M, what's a W-2? It's a tax form that says you're an employee. Metamorph, what with that argument, couldn't Amber Heard sue any client of Waldman's? He speaks for all of them, smiley face. there is dangerous ground here to Adam Waldman going out and talking about something and then saying it's the client statements and are defamatory without any proof that that was the order instruction, that he served that role or otherwise. Lawyers, I don't know about, I can't speak for the whole panel, gives you a little skipped heartbeat when you look at how Waldman's up there.
Now, this may not fly, but what about, because to break the privilege, you could break the privilege with a third party, right? So if
there was a conversation that was heard.
Yeah, but if the lawyer conveys the privileged information to a third party, that would break the privilege. No,
sure, yeah.
No, not necessarily, because the client is the one that waives the privilege. So it's possible that the lawyer saying something a third party might not necessarily break the privilege.
All right, because it's all right, cool. Because I know if the extra person hears it, but I wasn't sure if the lawyer tells someone else, then does that break the privilege? But it makes sense because it's the client's privilege.
But the information that's being told isn't the privileged information here, right? Like, so he goes out there, he says it's his own opinion. You're not protecting that necessarily. You're protecting the work product and communications. They're really looking for Johnny Depp told him, to get on that wall and say these things. And they're not going to get that. There's really no thing about it. There's just really no way around the privilege. So as soon as he said it was the conversation with the lawyer, that's it. You're done. You're just done.
Yeah. Stop asking questions. Yeah, I know. Really.
Yeah. And so I don't understand how they're planning to even show that at all. But I'm reasonably sure that Judge A didn't just go say, no worries, the agency relationship has been established today during jury instruction review. So I feel confident about that position. But we'll see. You never know. It's been a wacky court case. Join us next week for the next episode of Johnny Depp versus Amber Heard. Thank you so much for the super chat. Gio
Judge
Rio
says, you know what? I've changed my mind. I really think we do another 4 weeks of testimony.
Right. Let's do
it out some more.
Let's do it some more. We're getting good ratings here, folks. They gave us a renewal.
That's right. Next on season 2.
That's right, on season 2. Gio Rio, ask Ian about PRAH, Amber Heard's PR, and Court TV, smiling, laughing emoji. Law and Lumber, Judge A had 3 felony sentencing after the 8 a.m. Johnny Depp, Amber Heard motions. So yeah, she only gave them a very short window of time. Kurt, I tend to agree with you. Might not be finalized yet, but somebody's leaking to Court TV and potentially the New York Post, right, Nate? Ellie Rod, thank you. Appreciate both your insights, virtual legality, and Kurt and Nate. What's your emoji, Nate?
I don't even know. I think it's the crystal ball.
It's the owl.
I had this.
I think it was the owl, wasn't it? That was suggested for Nate.
Well, the crystal ball is good though because he's the Loracle.
Yeah, that would be good. A crystal ball, I'm down with. You got to pick one.
That streak.
Leaks. Eyeballs looking up and away. Emoji. It doesn't exist until the judge signs it. I mean, we'll see. So. Nobody's seeing the order. Calvin Wilson, Amber Heard's lawyers are recalling Johnny Depp. Finish her. So yeah, I don't know.
There's no way that this is a good plan.
I refuse to believe it's actually happening.
Is this?
I think it's leaked out to a friendly outlet in order to make Depp's team try to prepare for it and waste time. And I don't believe he gets called. I'm sticking with that.
Seriously, how much time do you really burn to prep?
Their strategies are all over the place, Kurt. I didn't say it was a good strategy. They wound up in the last week of the trial with 10 fewer hours. They're not masterminds over there right now.
This is all part of the plan, right?
Yeah, it's going exactly
according to the QAnon territory. It's all part of the plan. Here's how I'm still.
Look, you just got me demonetized, Kurt. You're killing me. No, I'm just.
January 6th.
Stop it! What are you doing? I'm talking over you, Nate. They are putting up crystal balls in the chat here. Allison Becca. Cool. Allison Becca. New York Post was 2 days ago saying it would be risky. It's so risky. They could run out of time. They could prove nothing. The jury could be reminded of how charismatic Johnny Depp is. It's very, very risky.
This stream is brought to you by ivermectin. Ivermectin is a wonderful new drug that you can take to help you with the COVID.
Kurt, what are you doing? Kurt, you're killing
Ask your doctor if ivermectin is right for you.
Aquamarine, thanks for helping the world understand U.S. law. And then a 4-leaf clover. Thank you so much. I'm Z. What, if anything, is a dumber idea than to call JD? This is pretty high on my list for things they shouldn't do with their remaining time. So go for it. Go for it. Let's see how it goes. Kim Mem, I just finished the last video and noticed you're streaming again. This was not my intent. This is a short video. It's at 45 minutes already. Yeah. Hoeg, you're a machine. Love Curtin Nate. What's your best tip for both sides? Oh, it sounds like the tip for Amber Heard's side. Don't call Johnny Depp.
Just pray. Find God. Find Jesus. Jesus forgives.
I think Johnny Depp's side should be calling what we know they're going to call. Dr. Curry. Somebody called Jennifer Howell, which apparently has some good info for everybody. And, using that 10 hours to basically show that Johnny Depp is a nice person and point out the flaws in the various stories that the Friends and Amber Heard have, especially when compared to each other. It's easier to argue that side right now from what we have seen than Amber Heard. What do they have planned for Johnny Depp? I have no idea. Electric Moccasins calling Depp to blame him for speaking slowly when they run out of time. And if they lose, it's not going to work. We know he speaks slowly. The biggest advantage there that he has set up in this case is that we know he talks like this. And we know he goes around in circles for answering questions. So you're going to have Rottenborn up there screaming against him to get back on track. And Johnny Depp is going to try to answer it in the Johnny Depp way. So we'll see how it goes. They're going to try to get him on tilt, I would imagine. They're going to want to try to matlock him, but I doubt it. Barcoded droid, Elaine overplayed with Waldman. If she would have stopped, would have been more effective. The 75 or so makes the jury think the question lawyer is trying too hard to break the rules of law. It is possible. I don't know how that was perceived by the jury, but certainly it didn't look good from my perspective of trying to just get attorney-client privilege assertions all the time. Nate, did you talk on that? What did you think of that attorney-client deposition of Adam Waldman?
I didn't see it. I didn't see that deposition. But there's the problem is unless it's like heard by a third party, right, or falls into one of the exceptions, then you're done, right? It's not crime, fraud. It's not in any of the so. I just don't see how you get around it. I was even thinking, I forgot there was one that I was thinking about where it was like not in a, because I know some jurisdictions limit it to only things in concerning matters of law, whatever in the course of business, but that was exactly what he was doing, right? He was so I just don't see any way around the exemption. I just don't see him.
Dad Hoeg is in the chat. Congratulations on 93.5, Richard.
Woo!
Yeah.
Thanks, Dad. I will get to your super chat, Dad. We don't play favorites here.
To me, it almost seems like his testimony is irrelevant because without being able to pierce the privilege, you don't really have anything.
I don't see a scintilla of evidence to get you to agency relationship for purposes of those statements. I'm going to use scintilla until the cows come home because that's what she used in the last motion to strike. That's
what she said.
Yeah, she said the Heard team argues that there could be a problem with the reproduction and the headlines and everything else of the article, and she says something along the lines of, if there's one scintilla of evidence that a jury can find on it, it's going to the jury. So that's the rule. Very, very high standard.
Is there a peppercorn?
I don't know. I know nothing about peppercorns, but I do know about scintilla. So Lord Luke M says the New York Post article says told the Post last week. Old. If it is an article that has been either rewritten or popped up from the leaks that happened during the 10-day break, which also went to Court TV and also appeared to be from Heard's team, that was when they said Johnny Depp was going to be recalled. That's when I tweeted out BS. I thought that there was very little chance of that. So it'll be interesting to see what the sourcing is on that, because all I have right now is like an avatar of Nate hurling invective at me in sound form.
Oh yeah, the New York. Well, the reason why there's two sources that are calling. One is entertainment. E-News is reporting it.
Okay,
but I'm not sure if their source is still the New York Post, because I'm thinking the New York Post reported it on the 12th, and they also reported it again yesterday, and saying again they had, and their reporting says that they have a source close to the team. Now the New York Post is one of the few pro Amber rags, so. Yeah. They've reported it twice and sourced it. I'm thinking it's accurate. And then E-News usually, let me see if if TMZ's putting it out, I think we're good.
You're trusting TMZ as an authoritative source?
We know that's Amber Heard's pipeline.
I trust TMZ. I trust TMZ more than the New York Times. I would trust TMZ more than the New York Times.
That's also a fair point.
Now, I don't know if there's overlapping articles here, but Apple Pie says New York Post said expected to be questioned as a rebuttal witness on Wednesday or Thursday. That would be Johnny Depp's team. So I don't know what's happening here. We're going to have to look at those articles. but it is curious. It is curious. Gio Rio, JD could be called back. Remember the same? Scrolling a little bit here. Gecko Gamer, is there going to be a vid on the Musk meltdown? Yes, Elon Musk sits at the top of my proposed virtual legality videos on my checklist here. I am so short of time. I'm going to get to it. There's crazy stuff happening in Muskland. I will bring that up. Law and Lumber, Rob, check mark that bullet list next to your monitor. Time management. I'm doing my best. Doing my best, Rob. MYH10, apparently Kurt turns purple when really amused. Dad Hoeg, congrats Hoeg on 93.5 thousand. Wow, we've had a very good day today.
Hoeg.
Dad Hoeg. Wow, thank you so much, Dad. I appreciate it.
HOEG.
Okay, all right. Super Gecko 90. Do you think they are calling JD to try to get around the privilege? That's not how privilege works.
They can't do that.
It's Johnny Depp's privilege to hold. So they could try to slip him up, but if he's not an idiot, they're not going to.
And his lawyers are going to be all over that. As soon as they start getting anything like that, objection.
Objection,
right?
Soliciting a breach of attorney-client privilege. They just get in there and don't let Johnny Depp answer. So if that's the goal, that would be silly. But they might be down to silly, right? At some point, your back's against the wall. I don't think Amber Heard's winning this case. Maybe they're down to hurling Hail Marys. We don't know. Asim 1, the report of final jury instructions is silly hysteria. Tend to think so, but people were asking me a lot about it, so I wanted to talk about it with you all a little bit. Jill Sanderson, can the judge sanction for leaking the info? Yes, if there was like definitive showings. I don't think she's going to get into the weeds that much.
No statements to the press, so there was that.
She did specifically say it, and I have a feeling she's getting upset about the circus stuff that's coming from both sides. Let's be honest, but predominantly right now, Amber Heard's team, and this so much feels like an Amber Heard leak. She might have a phone call, might be a little angry. I told you, counsel. Purple Pineapple, can't decide who to watch. You guys, Alita or Tug, you're all amazing. Opinion, I'd love it if the jury just awarded JD $57 million. Probably can't go over what was asked for, but I think $7 million is in play. We got Nate adding things. He wants to talk about this. Amber Heard calling Johnny Depp back to the stand could be risky. And that's expert, so that's like an opinion piece.
This is their opinion piece. And watch when you scroll up. This is what they say. Sources close to Heard told the Post last week that Aquaman actions plan to.
Yeah, so that's during the 10-day break. We saw that leak. I talked about that.
And then E News is also saying the same thing. So again, I'm not sure if they are going to call him, but the New York Post is so much into it. I'm assuming they may. And here is E News.
And what day is that from?
This is yesterday.
Okay.
And the headline, Amber Heard's team to call Depp back to the stand. Experts weigh in about whether it's a good deal or not. So.
I think we have a media short circuit.
Is there someone who thinks it's a great plan? Because I'd like to hear their opinion.
I don't know.
I think we have a media short circuit here. I think we have the New York Post getting that leak from before, filling space, filling time on their website. We passed really the point of no return where Johnny Depp makes sense. They thought he was going to come in as part of the Ellen Barkin block. And then, it's possible they could call him on Monday. I'm not trying to say it's impossible, but I don't think the New York Post has better information on May 18th than they did on, May 12th.
Yeah. And
I think this is a short circuit.
Yeah. I don't know. It's because it's such a risky play. Like if you're going to do it,
that's the lawyers in this going, why would you do that?
Yeah. It just doesn't make any sense. But we'll see. We
will. Ladybug82SW, what, if anything, is keeping you from liking this video and subscribing to Hoeg Law? Is it Elaine? What, if anything, is not a cure-all? We know it's not a cure-all. Even if she tries to tell you that it is. So, what, if anything, is keeping you? Like and subscribe. Thank you so much. We already have 2,500 people watching this.
Pop over Lolitas. I'll see you
guys later. Very, very cool. That's very cool. Well, I wanted this one to be useful. Oh, did Kurt leave? I'm sorry, Kurt.
Yeah, Kurt's going over to Legal Bites. He said she's up.
I don't think Legal Bites. She hasn't opened the gates yet from the last I saw, but maybe she did.
Yeah, she put the link out.
Okay, good. Let's just finish this off, and I'll pop my head over there too.
Cool.
It's just got a few more here. Crafting and Creating with Caroline, which I still love as a name. Fantastic name. What is the over-under on a motion to strike Amber Heard's counterclaim? There is no number, high enough.
I'm at 90%. Oh, you're like it's guaranteed.
Oh no, well the motion to strike is happening, whether it's granted or not.
Oh, the motion to strike is happening. Yeah, I'm thinking like it's 90% going to be granted because I don't think they put enough evidence in for that.
That's funny. That's funny. I am on the opposite side. I am thinking that the judge just wants to send everything to the jury. And even though I personally would kick it out, I think the judge keeps it in. That's where I'm sitting right now. It'll be very interesting on Monday.
Yeah, that's true.
Calvin Wilson, if a lawyer's statements can be considered defamation, haven't there been multiple instances of defamation during this court case alone? No, that's litigation privilege.
Yeah.
So Adam Waldman is sitting out there on the steps of wherever talking to the press. That's not litigation. When you're in court, you can say whatever. You have to do it under oath, obviously. And there are rules designed to protect against things like false statements. But you can say whatever, and that's not defamation because you are pursuing a legal remedy. And sometimes that requires saying some bad things about somebody else.
Yeah.
Don't want to miss any here. They're all flying around. Mostly dead, sus. Amber Heard claims cops called other times, but doesn't produce reports. Yeah, did you notice that? Why didn't JD press her on that? Well, they called the metadata guy during rebuttal. If they have a metadata guy that's useful, I don't even know that the photos are that useful as presented, so who knows?
Yeah.
They're not going to call that. They're not going to call the Unix guy if you're thinking he's coming back. He's done. You're never going to see him again. Future, can Amber Heard sue Adam Waldman for defamation if loses to JD? She's presently suing Adam Waldman for defamation.
That's what I'm saying. It doesn't make sense. Yeah, because she's suing Johnny Depp for things that he said. Then he's the chain, right?
I get what you're saying. I actually missed that completely. Too much streaming today.
Yeah.
Could she turn around and actually sue Adam Waldman?
Yes, she could.
Yes, but this was a countersuit to something that was already present that they came up with on the fly. And Adam Waldman's not as deep a pocket as Johnny Depp. He's not as interesting to bring the court case against. So yeah, she could go try it. Crafting and creating with Caroline. Also, the lawyer was showing the actual filing for the damages. JD's team is asking for $50 million plus. Okay, good to know. Then $57 million is in play. I still think that $7 million. If Johnny Depp wins, they're going to do something with that divorce money. It's come up too much in the court.
Yeah, but $7 million I think is gone.
$7 million just is in your head as something Amber Heard got from Johnny.
Anything above that I think is good, but it's like $7 million I think is going to be the baseline if he wins.
It's just poetic. Juries like that stuff. Sammy Robinson, should JD's team call Amber Heard back in rebuttal? No, I mean Amber Heard looks like awful. She's only going to improve her position. I think. It's eligible, but you give the other side the chance to potentially rehabilitate her somewhat. She looks terrible right now. There's no reason to call her back up. Ellie Rod, trying to keep calm, waiting for facts from the court on Monday. Media activity is sus, will raise your blood pressure. Nurse Liz might advise, take care of yourselves. I think I got a call. It was my wife's mother that was like, Rick's streaming too much. Don't let him have a heart attack.
Oh no.
We're going to be okay, Mom. We're going to be okay.
Yeah, we'll survive. We're surviving.
This is more fun than what I do in my day job. Crafting and creating with Caroline. I meant over under on the motion to strike being granted. I figured you did.
That's what I thought. Yeah.
Thanks, y'all. Loving your great coverage. That's why we talked about that as the second half of our answer, which is I actually think it's still 50-50 at best. Nate thinks it's a good chance because, my God, there is not evidence connecting.
Well, because you pleaded doesn't mean she's got defamation per se. I don't think she's pleaded malice. I don't think she's pleaded anything, right? But without going, it's like
she got some
about that claim. What I'm saying, motion to strike is if we send it to the jury, is there any question? Is there any way that a reasonable juror can say
it's that scintilla? It's that scintilla.
Yeah.
Is there a world in which we could imagine a person sitting in that room could look at what has been arrayed before them and come up with this conclusion? If the answer to that is no, the motion to strike should be granted.
Yeah.
And as Nate says, there's all sorts of holes in the countersuit. The biggest one for me is you're not suing Adam Waldman. You're suing Johnny Depp. You got to connect those pieces better than you did.
And that I think is enough.
I think it is too,
because you're suing the wrong person. Essentially, you're suing the wrong person. So
I think it's enough.
Because look at number 2. Did the defendant make the statement?
Yeah.
No.
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 You got to bring in the agency concept, and I don't think you proved it. And so, yeah, I think what happened today is they got a jury instruction approved for what an agency concept would look like, and that got reported as a finding. But we'll see. Yorkie Mommy, thank you for all that you do. I love the picture of the dog. Thank you so much. Wait, is that Is that the size of dog that was accused of bed problems in this case? Okay, I have questions. So I think we actually got done with everything. So thank you so much for a very short Hoeg Law headlines and hangouts of only an hour. I mean, we're doing good today, adding to the total of 7 today. Thank you so much to everybody. Thank you to my guests. Thank you to Kurt on civil law, Nate the lawyer. Go like and subscribe to their channels. Yes, if you like this content, like this stuff, tell YouTube you like it so that they know. Subscribe. We are achingly close to 100,000. That's gonna be a freak out day for me. So thank you everybody for popping in. Thank you for all the support from the super chats. I'm going to go see if Alita wants guests. And so if you're interested in hearing more from me, I'll probably be over on Legal Bites for a little while at least. So come on over, drop in, and thank you so much. Hopefully this was informative about what just happened from the Court TV leaks. Share it with your friends. I think some people on Twitter and social media need to see this kind of content. Thanks again, Nate, for dropping in. And I will see you all later.